Hello aspirants, welcome to Get Set Law Law Library. Today we are going to discuss a very important topic. I am sure all of you must have gone through the news by now. So today we are going to talk about the Electoral Bond Scheme 2018. Very recently on 15th of February 2024, Supreme Court of India has delivered a landmark verdict. And what was this judgment? This judgment talked about the decision of the unconstitutionality of the electoral bond scheme. So in this video, we will try to understand what was this electoral bond scheme and why Supreme Court declared it as unconstitutional. So stay tuned. Now, there was a 5-member bench which has been set up by the Supreme Court headed by the Chief Justice of India, D.Y. Chandrachud. And this bench last year reserved the judgment after hearing the petitions for 3 days. Multiple petitions were filed in this regard, which the major concern was drawing around the right to information which has been guaranteed under the Indian Constitution under Article 19(1)(a), which specifically talks about the freedom of speech and expression. So this was the whole concern, and now in 15th February the court has given the decision and they declared it unconstitutional as it was interfering with the right of information guaranteed under Article 19. So this was the decision of the court, and with that, Supreme Court has ordered SBI, the State Bank of India, was the authorized bank to collect the electoral bonds, and they have asked SBI to stop the collection of electoral bond immediately and submit all the data to ECI, including the name and amount of the parties. So this was a very significant judgment. And we will also see that why Supreme Court has declared it unconstitutional. So one of the ground, Supreme Court also quashed the amendment which has been done under Representation of People Act 1951 Section 29C. सेक्शन 29C एक बहुत इम्पॉर्टेंट बात डिस्कस करता है. सेक्शन 29C स्पेसिफिकली ये बताता है कि क्यों एक पार्टी जो एक फंड कलेक्ट कर रही है उसमें अमाउंट की क्या लिमिटेशन हो सकते हैं. सो दे हैव डिसाइडेड अर्लियर दैट 20,000 अमाउंट विल बी सेट एज अ बेंचमार्क, और जो कोई भी पार्टी एज एन इंडिविजुअल 20,000 से ज़्यादा डोनेट करता है उसकी डिटेल सिलेक्शन कमीशन ऑफ इंडिया को मिलनी चाहिए. लेकिन 2017 में पार्लियामेंट एक अमेंडमेंट लेकर आती है, और इस अमेंडमेंट से विच वाज डन अंडर फिनेंस एक्ट 2017, इस अमेंडमेंट से वो ये क्लॉज को रिमूव कर देते हैं, एंड नाउ द कंडीशन ऑफ डिक्लेयरिंग द नेम ऑफ द पार्टीज हु आर डोनेटिंग मोर देन 20,000 इज बीइंग रिमूव्ड. सो this led to although the government claimed that anonymity of the political donors need to be maintained, but this was denied by the court, and they said that this amendment is unconstitutional. So this amendment was also being quashed. Now Supreme Court has certain reasons on their bucket to declare this as unconstitutional. First is obviously right to information violation. So it is important to understand that how right to information takes place in our life, and as we all know that under Article 19(1)(a) we have got this right. Now Supreme Court का मानना है कि इस specific case में when we are living in a democratic era, it is important that every citizen have this right to know about the political party, क्योंकि हम एक डेमोक्रेटिक स्टेट में हैं, एंड जब भी सिटीजन वोट करते हैं तो सिटीजन्स को पता होना चाहिए कि वो कौन सी पार्टी को वोट कर रहे हैं और क्यों कर रहे हैं, वो पार्टी फंड कहाँ से रेज कर रही है. सो मल्टीपल इश्यूज आर देयर व्हेनेवर अ पार्टी रेजेस द डोनेशन, एंड सिटीजन मस्ट अक्रू ऑल ऑफ दिस राइट. Along with it, the proportionality factor is also being flagged here. The proportionality test has been decided by the Supreme Court back in 2017 when they were deciding the matter of K.S. Puttaswamy versus Union of India, where the significant right to privacy was enthralled by the court under Article 21. And at that point of time, they decided that Article 21 also contains the proportionality test, that whatever actions has been taken by the government or the parliament by the power of law, it must be in proportion to the effect it is going to put upon, specifically upon the citizens. So that has also not been met in order to justify the curb of black money. क्या हम ये ensure कर सकते हैं कि इस step से हमारी black money curb होगी? So this specific step was not being proved. Along with it, court also said the kind of unlimited corporate donations are coming, this is actually not good. So ये बहुत important factor है कि corporate donations जो पॉलिटिकल पार्टी रेज करती है उसकी एक कैप होनी चाहिए. अदरवाइज देयर इज अ वेरी सिग्निफिकेंट सेइंग दैट द रिलेशन बिटवीन द गवर्नमेंट पार्टीज एंड द कॉर्पोरेट्स आर ऑलवेज बीन डीम्ड to be in a good one because both are deriving benefit from each other and it is not in the interest of citizen. And इसीलिए सारे citizens का ये right है कि उन्हें पता होना चाहिए कि political party कौन से specific corporation से या individual से एक large amount of money raise कर रही है. And now you can see in the screen that we are displaying the data. The source of is data from Drishti IS. And we can see that the total amount of electoral funds have been collected is around 9,208.23 crores. This is a great sum. And you can see the data is from 2017 to 18 to 21 2022. अब इसमें हम देख सकते हैं कि बीजेपी ने सबसे ज़्यादा पैसे रेज किए हैं, which is close to 5,271 crores. Followed by Congress, which is 952 crores, followed by TMC, Trinamool Congress, which is 767.88 crores, and followed by Bharatiya Janata Dal, which is 622, and DMK 431 crores, and followed by other parties. So this is a very, very significant amount raised by the political parties across the country, maybe the individuals and the corporates and any other organization who are donating for this political cause. Now we will try to understand what is electoral bond and what is the need and what is the use and how it came into existence. So electoral bond are basically instrument. It is like a promissory note. If any commerce students are there, they must be knowing what is promissory note. So basically अगर हम इसे simple terms में समझें तो promissory note का मतलब होता है या फिर electoral bond का मतलब होता है कि हम एक amount के बदले में हम एक paper exchange करते हैं, which is in a format called bond. It is a legally recognized paper. It's not an ordinary paper. तो इस paper से जो पॉलिटिकल पार्टी होती है वो इस बॉन्ड के थ्रू उस स्पेसिफिक अमाउंट को बैंक से एनकैश करा लेती है. तो वी डू नॉट गिव द कैश डायरेक्टली टू द पार्टी, बट वी टेक अ बॉन्ड, अ पेपर, एंड विद दैट पेपर द पार्टी टेक्स द अमाउंट. सो दिस इज द प्रोसेस. एंड another significant step taken by the act is that this can only be maintained by State Bank of India, which is a government recognized bank. Along with it, only registered political parties can exchange cash in order of electoral bond. No other political parties who are not registered under Registration of People Act 1951, they cannot use electoral bonds. Along with it, the history lies that back in 2017, when we had Finance Minister Shri Arun Jaitley, he introduced for the very first time the concept of electoral bonds, and because the purpose was to introduce the anonymity, to introduce the transparency in the political funding, so that people must be aware that how a party is sourcing a fund. So this was the basic reason, and that is why the Finance Bill 2017 was introduced, in which this electoral bond scheme was tabled in the parliament, and they proposed amendment to various laws related to the specific area, and from that specific thing the electoral bond scheme came into the picture, and it finally implemented in 2018. Post that, in 2022, certain amendments had been made in which the period of bond collection has been increased. So जो इनिशियल पीरियड था सिर्फ 10 डेज का. सो अगर किसी भी इंडिविजुअल को बॉन्ड रेज करना है, so there are 4 specific months as you can see in the screen. The 4 specific months were July, April, January and October. So these are the 4 months. अगर आपको बॉन्ड रेज करना है तो ये 4 महीने का टाइम है. And first 10 days are allocated to raise bond. बट जब ये अमेंडमेंट लाया गया तो अमेंडमेंट लाने के बाद इस डेज को 10 से 15 कर दिया गया है, सो दैट मोर टाइम बी गिवन टू द individuals to raise the bonds. Along with it, validity has also been amended. Now validity earlier was 10, now validity has moved to 15 from the date of issue. So this is also important. Whenever the date of issuance is there, from that specific date, the validity will be counted to 15 days. Eligibility, as I mentioned, section 29A of the Representation of People Act 1951 says the political party registered under this act is only eligible to raise bond with this specific electoral bonds. So this was all for the electoral bond scheme, and since it was raising a lot of issues, multiple concerns were flagged by the different petitioners, of which the petitions were clubbed together and presented before the 5 judges of the Supreme Court, and now they have decided that right to information will prevail over the right to privacy of the donors who are donating towards this political cause. Since we want to promote the participating democracy, it is highly relevant that we need to promote the right of the citizens in large and protect the structure of democracy. So definitely please let us know what is your opinion in this regard, and we will reply you back. So stay tuned for more such videos and see you in the next one. Thank you.